The punishment range for that is a minimum of 2 years.
One of the questions that I get quite often,
they're driving on the roadway and they're stopped, they're alleged to be intoxicated, and they have a child.
Hi, I'm criminal defense attorney Tim Powers, and we're talking today about the Miranda Rights. One of the questions that I get quite often as a criminal defense attorney serving Denton and Collin counties is that my arrest must be no good because I wasn't read my rights. The Miranda Rights are a custodial interrogation rule, and they're not a predicate to a valid arrest. This is because television does a very, very bad service to the criminal defendant, and everybody assumes they have to be read their rights. Most defendants aren't read their rights until the next morning when they're arraigned out by the judge. The Miranda Rights is a custodial interrogation rule. If somebody is arrested, taken into custody, typically the bright line is when the handcuffs go on or when they're taken into the station and a detective or another police officer attempts to question them. If the rights aren't read, then the answers to those questions are not admissible. But a lot of times, Miranda rights are never necessary. Take the example of a DWI. An officer pulls somebody over on the highway, let's say for speeding. That person is in what they call an investigative detention. The investigative detention, you're not free to leave by any means. In fact, if you did try to leave, you would be arrested for evading arrest or detention. What happens is the officer is trying to gain information. Where have you been? How much have you had to drink tonight? I smell alcohol in your breath. Have you been drinking? Those questions are admissible because you're not in custody and they never read your Miranda rights. And they purposely do it that way because they don't want you to know the rights and they don't want you to be quiet. The fact of the matter is you don't have to say anything. You do have to identify yourself to the officer. You have to present your automobile insurance, your proof of financial responsibility, typically your insurance card or SR-22 in Texas. And if the officer asks you to get out of the car, you have to get out of the car. That's all you have to do. Quite honestly, you're never read your rights usually unless you're being questioned inside the station house or unless you're under investigation for a particular crime. Fact of the matter is, they don't void an arrest, but if you are being investigated, you should never talk to the police without an attorney there. If you need the help of an aggressive criminal defense attorney, call our office, the Law Office of Tim Powers in Denton or Collin County. In Denton, 940-483-8000. In Collin County, McKinney, 972-724-4820. We're there to get you the best result possible. If there's a way to beat your case, we'll find it. If not, we're really good at doing damage control. But don't go in there without an attorney. The Law Office of Tim Powers, Principal Office, Denton, Texas.